Hi, my name's Faye and I'm a building surveyor with Harrison Clarke Chartered Surveyors. Today we'll be looking at party wall matters from the perspective of a neighbour. If your neighbour is planning to undertake construction works to their property and these works are notifiable under the Party Wall Act, they are legally required to serve a party wall notice on you. Unfortunately, sometimes building owners fail to do this for several reasons. In some cases, building owners are unaware of the Party Wall Act or do not believe that their works are notifiable. Additionally, building owners will occasionally take the risk of not serving notice, assuming that their neighbours are unaware of the Party Wall Act in hope of saving costs. But where does that leave you as their neighbour? This video aims to explain what can be done and how you can protect yourself in these situations. In summary, notifiable works fall under three categories in the Party Wall Act. These categories are Section 1, building on the line of junction, Section 2, works to a party wall, structure or party fence wall, and Section 6, adjacent excavation and construction. We won't go into detail today about the exact nature of these works, but we have several helpful videos on our website which will provide you with more information. You can also call us to discuss whether your works are likely to be notifiable. If you believe that your neighbour is about to start construction works or they have recently submitted a planning application, we strongly recommend that you speak to your neighbour as soon as possible. At Harrison Clarke, we find that a friendly conversation can help not only build your relationship, but improve the outcome of your party wall matters. You may find that your neighbour does intend to serve notice on you, but is not ready, or they may simply be unaware of the Party Wall Act, and your conversation may point them in the right direction. If the meeting goes well with your neighbour, hopefully the building owner will serve you notice. It can be really problematic if your neighbour fails to serve valid notices. Although damage arising from notifiable works is not common, it becomes more likely if party wall procedures are not followed. The party wall process is designed such that the owner completing the works is required to consider the implications to adjoining properties. A party wall award will provide a framework and other tools for quickly and sensibly settling any disputes arising as a result of notifiable works, which will be absent if the building owner does not notify adjoining owners. If a dispute ultimately ends in court, courts are unlikely to look favourably on a building owner who has completed notifiable works without following the party wall procedure, and will likely be penalised for their failure to do so. Sadly, a friendly conversation may not be enough to ensure your neighbours follow their obligations under the Party Wall Act. When this happens, your main and possibly only option is to apply for a Party Wall Injunction through the courts. A Party Wall Injunction is a court order that results in the building owner having to stop works until the procedures contained within the Party Wall Act have been complied with. This will effectively make it a criminal offence for the building owner to continue with their works and ignore the injunction, as they will be in contempt of court, which can result in a fine of up to 2 years imprisonment. If you are in a position where you wish to seek a party wall injunction, your first step is to seek advice from a party wall surveyor to confirm whether or not their works are notifiable under the Act. You should also seek legal advice prior to taking any action, as there are significant cost risks to you as the adjoining owner should you choose to proceed. If necessary, we can work with you to find a suitable legal advisor. An injunction is not a quick fix or cost-effective solution to this kind of dispute. Firstly, you will need to ensure that you have enough funds to cover the professional fees of a solicitor and the court. Additionally, in the event the injunction is appealed or unsuccessful, you could be liable for the building owner's costs due to the result of delays. This can quickly rack up to tens of thousands of pounds. If your neighbour has already started their works or are preparing to start, you should consider instructing a party wall surveyor to prepare a photographic schedule of condition of your property. A photographic schedule of condition is a report that documents the condition of a property. The report is made up of two parts: a description of the building elements and their condition, and supporting photographs which back up the text description. Clearly documenting the condition of your property, ideally before building work start, will help make any dispute over damages much more straightforward for the surveyor to assess and resolve, as they will be able to easily determine if the alleged damage already existed or is new and caused by the works. If damage does occur as a result of your neighbour's works, you will be able to claim compensation from the building owner completing the work. If you are concerned that your neighbour may be planning or carrying out notifiable works and they have not served notice on you, please reach out to one of our experienced Party Wall surveyors by calling Harrison Clarke on 023 8155 0051, who will be happy to discuss potential options with you.